How can councils bring the interim accommodation duty to an end? Now, there's actually a few ways depending how you define it. It's actually quite an important question because it will often happen, and it's often something which councils can use to illegitimately deny housing to people by doing this wrong, effectively, by getting it wrong. So in order to explain it, and I guess just give it a bit of jargon as well, when we talk about emergency accommodation, the technical term for that is interim accommodation duty, and it's the duty that's provided under section 188 of the Housing Act 1996, if you want to get really fancy. And it's basically owed to anyone who applies as homeless and the council has reason to believe that the applicant might be homeless, they might be eligible, and they might have a priority need. Now, this is a designedly low threshold. It's basically designed so that no one who is actually in priority need and eligible and homeless is left out on the streets or left out in any sort of homelessness situation, to be honest. And as you'll see, it's one of the areas in which councils really try and push back very, very hard against, because in practice, once the applicant is placed into interim accommodation, it becomes much more difficult to shrug them off, basically. So lots of effort is often used to try to deny the interim accommodation duty at all. And then councils quite often will start to find ways to get out of the duty once it's been triggered. And unfortunately, it's just very, very complicated because the way the Homelessness Reduction Act works alongside the pre-existing kind of housing stuff. So I'll try and explain this as best I can, and I appreciate as I'm speaking it might just seem like it's just gobbledygook, but I'm going to try and make it clear as I can, as I say. So let's just go back to basics. You make a homeless application by approaching any department of a local housing authority and asking for help with housing in some way. It doesn't have to be a particular set of words you use or anything like that. If you just basically say to someone in a council, local housing authority, can you help me out with housing, or can you tell me how to apply for housing, or whatever it might be, that satisfies that first arm of that test. And second, you need to give them reason to believe that you might be homeless or you might be threatened with homelessness. And threatened with homelessness basically means you're likely to become homeless in the next 56 days. Which is as simple as saying, I'm homeless or I'm about to become homeless. That would be all you actually need to actually satisfy that duty. That is essentially set again as a low threshold, very low threshold. So once you've done that, the council very, very quickly needs to ascertain a few things. And really, I'd say, although these happen simultaneously in legal terms, in reality, I'd say a council should be looking at whether the section 188, the interim accommodation duty, is satisfied before they do anything else really. So basically the same day the application's made, if not in the same hour the application's actually made. So very quickly they need to make out some basic inquiries. That might be just about requesting information from the applicant. Things like, are you pregnant? Are you a British national? What's your immigration status? Are you actually homeless? All those kind of things. And if the answer's to come back to say, yeah, in the positive, as in it might be those things apply, then the interim accommodation duty is just basically instant. It happens there and then. And so that might be as simple as telling the council, I am pregnant, and therefore you'd automatically be in priority needs. Or it might be a case of saying, I've got a number of health issues or a number of kind of other issues that around vulnerability, institutional background, trauma, that sort of thing, which basically would also give the council reason to believe that they might be in priority needs. And particularly around vulnerability, councils just act really dastardly, basically. I've been very polite about it, but really some of the most grave injustices that happen in this sector happen around people who are very obviously in priority needs, being told there is no reason to believe that they might be, and therefore they're denied that interim accommodation duty. And that would be particularly relevant around things like verification of rough sleepers, because most rough sleepers will be in priority need through vulnerability. Let's say they're a British national, so they're likely to be eligible as well. And obviously they're telling the council they're homeless through rough sleeping. A lot of councils, rather than engaging with section 188 on the day they should do, they're basically telling people to go and go and rough sleep again, and we'll get the outreach team to come and find you, which is definitely unlawful. And why it's so prevalent in the sector, I don't know. Well, I do know, but it's not. There's no good reason for it, basically. So the interim accommodation duty is triggered, and that also is then generally followed by the council very quickly working out, is the person actually homeless, so carrying out some inquiries there. That might be a case of contacting the landlord or something to confirm that the section 21 has expired or something like that. And it would also include things like, as I say, inquiries into eligibility around nationality or kind of recourse to public funds, that sort of thing. And once the council is satisfied that you are homeless and you are eligible, which, bear in mind, can take a little bit of time, but generally speaking it would be done within the first few days, certainly no longer than that. The council then has a duty to carry out an assessment of the person's situation, which is the section 189A duty, to kind of work out why they became homeless, what type of accommodation they need, what support they might need to maintain it. That then leads to the personalised housing plan being created, and that would also be the point that the relief duty started as well, which is the duty for the council to try to stop that person being homeless in some way. Lots of other complications arise from this. That's probably all I say, other than the fact that the relief duty should really last for 56 days. Certainly in cases where you're owed the main housing duty, which is the really good one, which is when you're homeless, eligible, in priority needs, not intentionally homeless, and you have local connection, then they should be issuing that decision on day 57. That's what the guidance says. And in exceptionally complex cases, the guidance gives the councils another 3 weeks to conclude their inquiries, but really that's going to be quite rare in practice. So you've got this kind of relief duty, which generally doesn't interact with the interim accommodation duty. They kind of run parallel, except that the timings do have an impact on each other. So for example, if the council is slow to start the relief duty, that 56-day period, that essentially means that they're going to have to offer interim accommodation for much longer. And I guess it's probably worth mentioning at this time, the interim accommodation is basically the accommodation you get between making the homeless application and triggering section 188, and a final section 184 decision been reached, which, as I say, should generally speaking be little more than 56 days. It's not unusual. We've had cases where actually that could last for a year or something, which is ridiculous, but that's kind of the reality of it at the moment. So in cases when you're definitely in priority need, in effect, you are always going to have that relief duty lasting for at least 56 days, and really that decision should be reached on day 57. And that is when the first set of circumstances arise when the council can end the section 188 duty, because effectively, let's say you're owed the main housing duty, so you're in priority need, you're not intentionally homeless, and that day 57 comes along, they issue a section 184 decision which says, yep, you're in priority need, you're not intentionally homeless, we owe you the main duty. We're therefore going to end our section 188 duty to provide interim accommodation, and we're going to now provide temporary accommodation under that section 193 duty. The section 193 is the main housing duty. Now that might actually be the same address, it might be that you don't even move, or it might be you've moved 5 times already by this stage, it just depends on the council. But that effectively brings the section 188 duty to an end, and you've then got the same accommodation under section 193. Now there's a few things that become important to probably bear in mind at this point, because generally speaking, you can't challenge the suitability of the interim accommodation duty. So if it's terrible, if it's in the wrong location or whatever, it becomes very difficult to challenge that without going through the courts. In fact, technically, it is impossible to challenge without going through the courts. Now, you can raise complaints and stuff and do it in sort of extra legal kind of ways. But yeah, generally speaking, you have no right of review at that point. The Section 202 review, which is usually open to anyone that doesn't have a solicitor, is not available in that stage. But once the main duty has been accepted, you can now ask for a review of the suitability of the accommodation through section 202, which is probably a good thing, because it might be by this stage you've been in, let's say, B&B for 8 weeks or whatever by that stage. You haven't really been able to challenge that yet, but then on day 57 of the relief duty expiring, you can then basically challenge the suitability through the review process without needing a solicitor. So that's a good thing. And equally, if you're in priority needs but you are intentionally homeless, you still have a further accommodation duty, only for a few weeks, but it's the section 190 duty. And again, that accommodation needs to be suitable. Will Flack, who I do the live stream with, he had a really interesting case where he successfully challenged the suitability of accommodation given under section 190. So it's clear again that all accommodation that councils offer has to be suitable. So that again would bring the section 188 duty to an end, and it would be replaced by the section 190 duty, which is going to last, as I say, for a few weeks before they then finally evict you. Other things can happen at that point, by the way, so I'm probably not going to go on that tangent today. So that's probably the two most established ways of the section 188 interim accommodation duty coming to an end, but there's other ways it can happen as well. So bearing in mind, section 188 is triggered as soon as the council has reason to believe that you might be homeless, might be eligible, might be in priority needs. If they then offer you accommodation which you don't like and you refuse, the council can very quickly bring that interim accommodation duty to an end. They basically say, well, we think it's suitable, you haven't got a right of a review at this stage, basically, you are going to be on your own for the next 2 months or whatever. And again, what should happen at that stage is that it doesn't end all duties to the person. The relief duty still happens, the PHP still happens, and if the person is in priority need and not intentionally homeless, the main duty would be owed at the day 57 stage. And if they are in intentionally homeless but they're in priority needs, then the section 190 duty will still apply. So refusing interim accommodation is not the end of the world, but it's not a good idea. That then gets very complicated, because There will be situations where you don't refuse the accommodation, but you tell the council, look, I don't need the interim accommodation right now because I can stay with my family in the short term, and council should be very cool with that. Basically, there's a very interesting case from 2016, I think, where essentially that kind of principle was set out, if it hadn't already been set out very clearly already, because essentially often that will be the case. You can stay with family in the short term. What the council should say is, that's great, go stay with your family. If the relationship breaks down with your family, though, just to let you know, we do owe you this section 188 duty, so come back to us and we'll then provide suitable interim accommodation to you. That's what they should say. I'm not sure how often that will actually happen. So refusing interim accommodation can bring that duty to an end. And equally, if you were to break the rules in the interim accommodation, so let's say you got placed in a B&B, first night in the B&B you have a smoke in your room or something, stuff which is clearly not according to the rules, and the B&B manager basically kicks you out or something. So again, the council can treat that as implicitly refusing the offer of interim accommodation. And again, it doesn't stop the whole process. The relief duty still happens, the inquiries still happen, and that final decision will still be made, which might be positive, but you're going to be without interim accommodation for that time period. So often what you find with people who've been homeless for long periods of time, they've been round and round and round, you're like the 100th professional that they've spoke to, and you tell them, this is going to lead you to be to kind of get an offer of housing at the end of it. They'll often be very dubious about that because they just won't trust professionals in general. They've probably been promised the earth many times before, and so they don't treat that offer of accommodation as serious as they should do. So one of the jobs of professionals at this stage is really to be trustworthy, win over the trust of the person by just basically being true to your word and so on, and essentially finding a way to articulate and communicate the fact that this is actually a genuine opportunity for them to no longer be homeless, because they'll often have other offers of accommodation that look very similar, like SWEP and kind of these other things that happen around everyone in, and other things that happen around verification of rough sleeping process, that sort of thing, which basically hasn't resulted in anything useful at the end of it, or resulted in a really lousy offer of accommodation at the end of it, like the slum landlord type accommodation basically. So yeah, you just need to explain to people, you need to follow the rules, don't have parties, don't kind of smoke in your room, don't use drugs in the property, all that sort of stuff. That's really important if they're going to continue on that process and it to be as smooth as possible. So as I say, yeah, councils can treat those kind of actions as being an implicit refusal of accommodation. And the same would go if you just literally abandon it altogether, which again does happen. So they might get offered interim accommodation for a week and then they move out to family or something like that. Don't tell the council. Again, if you're actually in that situation, it's well worth having a conversation with the council and say, look, I've actually got this offer of accommodation from my family now for the short term. Can we just end the interim accommodation duty for the time being, assuming that the relationship stays the same with the family member? Now again, council should be cool with that. So that's the kind of second group of ways that the interim accommodation duty can be brought to an end. But the third one is the most complicated to explain, if this isn't already complicated already. Because basically, if you think about it, the interim accommodation duty is owed to anyone where there is reason to believe that they might be homeless, might be eligible, and might have a priority need. And it just triggered immediately, as I've said. Stuff happens on day one. It could be in the middle of the night, in theory, if you rang up the out of hours or something. So those three criteria, as long as those three things are always in play, the interim accommodation continues, basically. But let's say the council make inquiries and they essentially find out that actually you're not homeless after all. Let's say actually your Section 21 notice was invalid or something. You're no longer homeless. They at that stage would write a negative Section 184 decision to you, basically saying we've carried out inquiries, we're satisfied you're not homeless, therefore we're going to end the interim accommodation duty to you. That would be one way. Another way, which is probably much more common, is around priority need, particularly vulnerability. So let's say someone presents information to the council to say that they have X, Y, and Z medical issues, something like that. So let's say they've got diagnosis of PTSD, the history of trauma, that sort of thing. Now, councils really have to make inquiries of the treating professional, so GP, any kind of psychologist, psychiatrist involved. They may also invoke now medical or so-called independent medical advice, whatever, from whatever company, and they could come back and say, look, we've made inquiries and actually we've looked into the situation and we have found that actually you're not vulnerable after all. And sometimes that will be legit. Sometimes generally, if they're applying that initial low threshold properly, they're going to take in people who actually turn out not to be vulnerable after all. So that can be legitimate. But probably more often than not, it's not legitimate at all, because what councils do is they make inadequate inquiries, or they make no inquiries at all, or they give too much weight to now medical evidence, that sort of thing, rather than actually listening to the treating professionals who knows the applicant much better. And they basically reach a decision that you're not in priority need at that stage. Now, the good news is you can basically challenge that decision through the review process, through the Section 202 review process. And that's really kind of, I guess it's probably worth saying that that's when you really want to get a solicitor on the case, unless you've got a very good advocate on your side, because those kind of arguments become quite difficult to actually make if you're new to homelessness law. It can be done, but it's as I say, it's more difficult to make. But as I say, that is a legitimate, in theory, a legitimate way of bringing a Section 188 duty to an end by issuing a negative decision within that 56-day relief period, or 56 days plus the initial few days at the start of the process. I'm sorry this is so complicated, it's ridiculous, isn't it? But anyway, so although councils have to wait until the relief duty is ended to issue a positive decision, as in the main housing duty or the Section 190 duty, they can make a negative decision within that period if they've completed their inquiries and found out that the person's not in priority need, or they're not eligible, or they're not homeless. And so if any of those three things cease to exist, any of the three criteria, then the interim accommodation duty would end. But there needs to be a written decision, that's the key thing, and the written decision must explain to the person how to challenge it and what the reasons for that decision are, because at that stage you can provide more evidence, or you can kind of challenge the reasoning behind that decision anyway. So that, I think, is certainly an introduction to this kind of way this works. I know it's rather convoluted really, but yeah, that kind of gives you an idea of how this duty can end. What we often see in the real world is these so-called same-day non-priority decisions, and I'm going to do a long video about this at some point soon when I get time for it, because, as I say, if you approach your council and you give them reasons to believe that you might be homeless, might be eligible, might be in priority need, that might be, let's say that's at 10 a.m. in the morning, that puts the council under a duty to provide suitable interim accommodation basically immediately, I guess realistically within a few hours, basically before nightfall, let's say that much. And so at that point in time, the council is very, very motivated to find some reason to issue a negative decision, if they even do that legitimately. Often they won't even do that, but let's say they're actually trying to follow in the process on paper, kind of paying lip service to it. They have this idea of the same day non-priority decision, where they make some very quick inquiries of your GP or whatever, and basically, then conclude that you're not in priority need after all. But the reality of that is that very often that's not going to be legitimate. There's an interesting case, which I'm going to explain in more detail, called IA versus Westminster. And effectively, I think IA was female, I'm not even sure about that. But basically, let's assume she was a refugee who'd been tortured in her home country, might have been Afghanistan or something, I can't remember, which had caused significant trauma. She was under the care of a psychiatrist and some other professionals as well. And effectively, the council, I think, did get a same-day letter from an independent medical advisor. I'm not quite sure if that was the same day or whatever. I think it was. And basically, that just downplayed all the evidence from the psychiatrist and other professionals. And effectively, in that case, the judge said that where there is something as significant as something like PTSD, or kind of traumatic histories or whatever, there is no way on earth a council can legitimately issue a same-day non-priority decision. It's going to take time. It's going to require making careful inquiries to a number of organisations and professionals, getting that information back, potentially then sending that information that you've got back to a medical advisor, whose job is only supposed to be to help the council understand what those diagnoses actually mean. Nothing more. They often, certainly now medical, have been kind of criticised quite a lot for going way further than that and kind of giving opinions about stuff which is just not their place to give. So, and then even in the IA case, it actually says that once you then get that back, you then need to send what now medical have sent you back to the psychiatrist and actually treating the person, and basically allow that evidence to be kind of weighed up and put to the applicant as well, in case they want to give a second opinion about it. So that process is going to take days, if not a few weeks generally. But councils often do these same day non-priority decisions, and that's even if they've accepted that the person might be in priority need. Which again, we continually see with Bedford and other councils, where people who turn out to actually be in priority need, so they definitely are in priority need, initially they were told there was no reason to think they even might be in priority need, even though the same evidence was available at the beginning and at the end of the process to the council. Now, that's not to say they actually made inquiries, because that was the problem, they didn't make the inquiries. But actually, had they made those inquiries on day one, they would have realised very clearly there was reason to believe they might be in priority need. So yeah, I'm going to do more about that probably with Will Flack at some point soon. We're going to go and explore that in a bit more detail. But I'm hoping that just kind of helps understand how Section 188 is triggered and also how it comes to an end. As I say, big picture, it comes to an end if the main duty or the Section 190 duty is owed and it basically becomes temporary accommodation, or the applicant basically doesn't follow the rules or abandons the property, which will be taken as a refusal of that interim accommodation, or the council reaches a negative decision between making an application and the final decision being reached, but it needs to be legitimate. And in cases where there is significant complexity, that is not going to be done in one day. There's just no way on earth that can legitimately be done in one day. So yeah, hopefully that all helps. As I always say, if you find this stuff useful, do subscribe, because you'll get notifications of new videos about live streams, stuff like that. We've got some cool stuff in the pipeline actually coming up in the next few months. And give the video a like if you found it useful. And if you haven't done the training, if you've not considered doing the training and you're in a position where you're helping other people, I would strongly recommend the training we do, the online training. It's 30 quid if you're coming on your own back. It's £60 if you're coming from a professional organisation or whatever. If you're homeless yourself, I suggest you stick with the live streams that we do on a Thursday night and all the information already available. But the training, what the training does is basically give you an overview of the underpinning principles of housing law, which, given if you're actually homeless, you're probably going to be dealing with a couple of issues, might not be the most relevant way of doing it. You're better off just finding the relevant video on the channel. But if you're a professional who needs to understand how to actually help people access this assistance on a regular basis, then I'd say the training is awesome. It's currently got 4.9 stars on Trustpilot, which is actually quite difficult because of the way Trustpilot works. And we continually get feedback saying that this has essentially been either the best training they've ever had, or it's genuinely been life-changing in terms of how it's changed the outlook of that professional and how they're basically dealing with homelessness. So highly recommended, I'd say. If you've got questions about the video today, stick them in the comments and I'll take them to the next live stream. We do it every Thursday, or most Thursdays, at 7:30 PM. You don't have to watch it live, it's recorded. You can look in the live section of the channel to find out previous ones. And I try my best to do an index of questions that we get so you can kind of follow where your question is going to be asked. Make sure the questions put onto a video rather than a post, because I missed a few recently where the comments been put onto a post, which for some reason I don't get notifications about. So keep it on the videos. Don't put it as a reply, because again, notification system is weird on YouTube. You don't actually see it all the time. Just make a fresh comment, put your question in there, anonymize it. Don't put personal data on the internet, basically about you or your family. So basically just ask it as a what if question. What if someone was in interim accommodation and they were told they were not in priority needs and there have been inadequate inquiries, what would the law be? That's a question that we can answer very easily on the live stream. Rather than saying I'm in temporary accommodation and they've given me a negative decision, because then again you have to share a lot of information which is just private. So just don't do it. Basically just keep it anonymous, keep it as what if questions. You're going to get the same answer. So yeah,